conduit, and that lawyer got 90 days. Lots less. And the Abrams case was just as systemic, just as pervasive, because it's the relationship.
But you know
that's
what
wrong.
troubles me about that is this case was a case involving a lawyer who had represented this person at an unlicensed practice of law situation, and it seems to me that he has now put her in the same position to be able to have the unlicensed practice of law.
In the end result, it did. It doesn't mean he didn't try to do it the right way. And the last thing I want to leave the court with is there's evidence of mitigation, there's character testimony, and I know in each of these cases the standard for disbarment is high. You want to find that this is a lawyer that cannot be rehabilitated, should never have been a member of the bar. And if you look at the mitigation present in this case, the resume my client presents, that he is a good lawyer, had a bad relationship that encompassed only a part of his practice. Thank you.
In the 1 minute, I will address the cases for disbarment.
Okay, because we really here, you know, if it has a reasonable basis in the case law, we uphold the referee's sanction of 3 years.
I believe that the 87-page long report of referee, it gives competent, includes competent and substantial evidence. There's no doubt about it. If you look at that report, it was broken down in 28 counts. It's solid.
But we take it that it's all
Yes.
true. Now, why don't we uphold the 3 years?
Because the start point for this analysis comes on the, is the Elster case. The Elster case, this court found a 3 years suspension was appropriate for only one type of misconduct. We have 4 different groupings of misconduct. That's what I was saying at the beginning. We have, we have the issue of the violation of the injunction. We have the issue of his relationship with the clients. We have the issue of his business relationship. And this one case only dealt with one area, which was the communications between the attorney and the client in immigration matters. You have to multiply that by 4 different other areas of misconduct in this case. So the Elster gives us the bottom line for one type of the 4 types of misconduct we have here.
Does it all arise because of the relationship? In other words, did he independently, as a lawyer, say that this was another lawyer that was in partnership? Were there gross acts of misconduct independently from the relationship?
Absolutely. Mr. Glueck lied to the bar during investigation. He tried to misrepresent his relationship with Ms. Betchinger, never mentioned her name in any of the responses, never mentioned that he had a law firm at that location. So when the bar started asking him, but the clients are telling us they went to your law firm, everything starts unfolding. After the sworn statement I took from Glueck, where he denied having Ms. Betchinger work for his law firm, I showed him at the end the card with her name as paralegal, and then through his counsel, he comes and says, oh, I did have a satellite office at Millenia. 2.5 years after he started denying that he had anything to do with Millenia's improper handling of the cases.
Maybe you didn't understand my question. My question was really that if she had been a lawyer, in turn, because you talk about the client that's 7 months at Crohn's, did he commit violations, separate violations in incompetently representing people and abandoning them? Were those separately charged, or does it all arise because of the relationship with?
If she were an attorney, he would have had a problem with all the letters that were coming back asking for follow-ups on the applications, and nobody responded to those. Nothing was done with those because those were going to the Millenia closed location. So if she were an attorney at that point, they still abandoned the clients because things were not being responded to. So there's no doubt that he abandoned those clients. And I want to say something else on the injunction, because we have focused on the forms. The injunction actually says in letter G, taking inquiries or answering questions from persons which particular INS forms and applications are suited. So she was the person answering all those questions because that is the evidence from the complainants. So it's not about the forms that he gave her. She was the front person of that operation. It's proven through the testimony and is consistent from all these people that were heard. These immigrants, that some of them we brought from Brazil, some of them were in other states. I mean, he really affected these people's lives and their dreams to become immigrants. It's wrong. He actually targeted people that are desperate and people that were vulnerable.
Was there any attempt to punish her by the bar when she came back to the country?
She left Brazil. We don't know her status. And I will ask the court.
She didn't testify at the hearing?
No, not at this hearing. We don't know where she is. Please, the court, look at the Mitchell case, which looks at the frequency and totality of the complaints. Please look at Williams. Court deals more harshly with cumulative misconduct. This case deserves disbarment. What Glueck did is unacceptable. He has been in practice for 31 years. You don't do this to clients. He must be disbarred. It's the only fair conclusion in this case. Thank you very much.
Thank you very much. We'll take the case under advisement. Court will stand in recess.
Thank you for your time. Have a great.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.